Good morning. I will give you, talking about crash course, I will give you a very short crash course into the decision-making process when we are incorporating EU law and making it EEA law. I might add that we do everything that I will touch upon this morning. We do have breakout sessions in the afternoon where we go. Where we have the chance to go into much more detail into all of these things. So this is just a rather kind of a short glimpse of how the decision-making process works. And I think it's always kind of useful when we are talking about something to start with why we are doing it. Why are we incorporating the EU law into the agreement? And the starting point for everything related to the EU agreement is the main principle of the agreement, which is homogeneity. EEA is based on applying the same rules and interpret them and applying them uniformly. The homogeneity has different dimensions. You have the judicial dimension, you have the surveillance dimension, but you also have this dynamic dimension that I will refer to as the dynamic dimension, which is referred to in Article 102 of the EEA agreement. Basically, the need to constantly update the EU agreement so it reflects the internal market law that is applicable on the EU side at every given time. And that requires us to be constantly updating the agreement. And that, of course, requires the decision-making process, which I will try to explain. Now, the second question is what? What is it that we are actually taking on board? What scope of EU law are we making part of the agreement? And the EEA agreement is, of course, founded on the internal market, on the four freedoms: free movement of goods, services, capital, and persons. It means that, and this has already been mentioned, policy areas that fall outside of the scope of the internal market on the EU side, like agriculture, common trade policy, are outside of the scope of the EU agreement. So it's only the EU legislation that falls under the scope of the agreement, i.e. internal market legislation, that we do take on board into the agreement. And we refer to this term as EEA relevance. EEA relevance is not a term that is found in the agreement itself, but when we discuss what EU legislation should be made part of the agreement, we use the term EEA relevance. Then the next question is how, and this is the kind of the main scope of what I will be discussing today. How does the incorporation procedure work? And the first thing to do after the EU has adopted new legislation that falls under the scope of the agreement, is EEA relevant, is to assess the act. The EFTA Secretariat monitors all EU legal acts. And once the EU adopts a legal act, the Secretariat will conduct a preliminary assessment of that act. The key question when we are making this assessment within the Secretariat is the act EEA relevant? Does it raise any horizontal challenges? And do we need adaptations to it? And I will explain a little bit what we mean by adaptations later on. But the first step is that the Secretariat make this assessment and kind of pre-screens all new EU legislation. If the conclusion is that it is indeed or would appear to be EEA relevant, the next step is to send it to our member states for assessment by the experts in the EFTA states. There are essentially, for most acts, two different procedure or ways to conduct that assessment. We refer to it as either the standard procedure or the fast-track procedure. The standard procedure is the main principle, while actually I think that there are more acts that are incorporated onto the fast-track procedure. But if it follows the standard procedure, we request that the experts in the EFTA states that are part of the working groups provide us with fill out a certain form to provide us with their assessment of the act. If it follows the fast-track procedure, essentially there's not a need for this assessment, but we inform them, and they have basically the ability to inform us if they agree that this act should be follow this fast-track procedure. So it's a little bit more streamlined and allows us to incorporate the acts more quickly. Now, when this assessment is finished, first the pre-assessment by the Secretariat and then the assessment by the experts that are in the working groups, we can start to actually prepare the legal drafting. And EU legislation are made part of the EEA agreement by decisions of the EEA Joint Committee. And it is the EFTA Secretariat that's charged with drafting these Joint Committee decisions. When we received we have received the necessary feedback from the EFTA states, we can start to prepare this drafting. Then we submit the draft to the EFTA states to approval, usually both to the working groups and the subcommittees. It is then submitted to the EU side, which then launches what is called inter-service consultations. Basically, getting approval from the relevant director generals of the Commission for approval of this decision incorporating EU law into the agreement. It is. I mentioned adaptations, and I will explain a little bit further in detail what we mean by that. But at this stage, it's useful to make difference between what we refer to as technical versus substantive adaptations. Essentially, if we have drafted in JCT adaptations that would be categorized as substantive, the Commission needs approval from the EU Council before it can approve the draft JCT. So that means, of course, a little bit more complicated and more lengthy process for incorporation. The formal decision-making then takes place in the EEA Joint Committee, and there are two important principles that really kind of govern that decision-making that is kind of worthwhile to touch upon. First of all, the EFTA state speak with one voice within the Joint Committee. And of that cause requires us to coordinate our positions before we meet with the EU side in the Joint Committee. And for that, we have the EFTA Standing Committee, which is charged with coordinating the position of the EFTA states. But to assist, as has already been discussed, to assist the EFTA Standing Committee in performing its tasks, you have 5 subcommittees to the Standing Committee, and then you have working groups and expert groups. The subcommittees, we have colleagues from the foreign ministries representing the EFTA states, but in the working groups you have the experts in the line ministry. So before any decision is taken, we have this mechanism to coordinate our position through the Standing Committee, but then being assisted by the subcommittees and the working groups. Then the second principle that is important to have and keep in mind is that the Joint Committee takes decision by consensus. And to assist the decision making by the Joint Committee, it meets around 8 times per year, and to kind of to prepare the meetings, to make sure that there is consensus on all the decisions that are to be taken. The EFTA Secretariat works with the Commission to prepare a list of the decisions that are ready for adoption. This list is called the so-called long list. We would sometimes like it to be longer than it can be, but it's usually quite substantive. And this is essentially a mechanism to make sure that the Joint Committee is ready to adopt all the decisions that it can be ready to do at any given meeting. Final on the formal decision making is that under the agreement, the EFTA state has the right to make what is called constitutional requirements to a decision. That essentially means that those decisions can be taken, but they will not enter into force until that EFTA state has gone through its own domestic procedure, usually parliamentary procedure, to get approval for the decision. And it's not until that EFTA state has informed that it can lift those restrictions that the decision will enter into force. Now, I mentioned adaptations before, and we will go into much more detail on this in this breakout session in the afternoon. But the way that EU legal acts are incorporated into the agreement is basically by adding reference to them in the relevant annexes to the agreement. But these legal acts have to be read in view of the adjustment made to them by virtue of provisions that are found in the agreement. These are what we call adaptations. So we just add a reference to them, but when you're reading and applying these legal acts, you have to be mindful of these adaptations. And these adaptations can be found in different provisions in the agreement or different places. First of all, we have Protocol 1 that contains what we refer to as the horizontal adaptation. Then in the individual annexes, you may have what we refer to as sectoral adaptations, and those are adaptations that refer to these specific policy areas that are found and regulated by the individual annexes. But then we have the third category, which are specific adaptation, and those only apply to specific acts. Now, this is kind of very much a crash course into this. We do have, however, not only the breakout sessions that I've been talking about, but we have a lot of resources on this available on our website. We have a web tool on how EEA law becomes EU law becomes EEA law. Sorry, typo there. Very useful to get a lot of information about the process I've been describing here. But also we have recently included very valuable information of how to read EU acts incorporated into the agreement, how to kind of make sense of these adaptations that I've been talking about. So that's it for me. Thank you.
Thank you, Finnur. Before we go to the next presentation, we've actually been getting in quite a lot of questions from our online audience. As I said before, we have about 130 people with us online. Marit, do you mind coming back up and answering a few of them? So the first one is, can an EEA member reject an EU legal act, not because it's not relevant to the EEA agreement, but just because they don't like it?
Yeah, that's a question we actually get quite often. As I described a bit earlier, there is a scope of the EEA agreement. Our parliaments have agreed to that scope with the EU side. That's the easiest answer, let's say. Having said that, there are sometimes in the borderline, but the sort of main principle is that if it is within the framework of the EEA agreement, we are obliged to take it in. In the end of my presentation, I was also talking about the challenges, namely this, that it is a bit inside and outside. And I think it's more in this part where we have challenges today, because we need to find solutions that not only our side, but also the EU side agrees to. And that can be challenging, and it can be challenging to, if you remember my favorite slide, to reconcile those two ways of working. So it's, I would say, mainly in this kind of area where we have the challenges today. I know it's not a straight yes or no answer, so I'm sorry for that, but it is really not a straightforward yes and no answer to that. And to give you a picture on what we're talking about 80% of 85% of everything we take into the EEA agreement, we take in without any adoptions, because they're in within, we see them as not complicated, they fit in with the framework of the EEA agreement, they're adopted as such. The remaining 15%, we need adoptions, and remaining, and here I don't have exact numbers, but let's say around 5-6% are the challenging ones, where we need to discuss with the EU to find ways of fit the EU law into the EEA agreement.
Excellent, thank you. Another question is, have there been cases in the past where it was difficult for the EFTA countries to come up with decision because the EU legislation was in this gray zone that you talked about, neither entirely relevant nor entirely irrelevant? Is there an example that comes to mind?
Well, I think this is a part of what we do every day, because it's not always like this, that this come up to the higher level in the EEA process. This is what my guys are discussing with the member states every day, with my legal officers, and also the legal officer in Finnur's team are discussing every day. Because as again, you know, if there are gray zones, it could be that parts of the legislation should be inside and parts of it is not relevant. So again, the agreement caters for that as well. We have opportunities to either have in this adoption text, it's possible to make either exemptions or parts of it. We have some of it, parts of it only for one country is also possible. So this is, but I can't come up with an example in my head just now. But I mean, this is something that it really happens all the time. So it's not something extraordinary, I have to say.
Thank you, Marit. Just the final questions. We have quite a few coming in, but in the interest of time, what are your options or instruments in coming up with this one voice among EFTA countries? What is the role, which is an EFTA member? Yeah, and then it's a question about Switzerland. What is then the role of the EFTA member that is not an EEA EFTA member in this? Thank you.
Thank you. Thank you. That's also a very understandable question. Well, when it comes to Switzerland, they are not part of the EEA process. So they don't have a say of what should come into the EEA agreement or not. That is strictly between the three remaining member states and the EU side. But if they don't agree, then, well, then they continue to discuss. That's just how it is. But again, you know, most of the time, I find that our member states are very flexible and understanding. And again, for the three of them, the same framework. It is the same framework. Sometimes we have discussions whether some things one country thinks this should be inside or outside. And sometimes we also have something which is outside the scope one of the countries are interested in having in. So, but again, this is something I think they need to discuss. The Secretariat is only the facilitator here. But I think the conclusion of this is basically to make the time running. I see Ari wants to, no, yeah, you want to comment? Come up, please.
Sorry.
No, go ahead.
No, I wanted to add that comment. In my introduction, I underlined the importance of trust for the functioning of the agreement, and I think that can be illustrated in the answering the question you just raised on, you know, on what happens if we don't like an act. I mean, there is a formal answer. I mean, by virtue of the EEA agreement, we are bound to including EU acts into the EEA agreement, which are relevant for the internal market. And if we don't, because, you know, there is a decision to be made to approve, we might not make the decision. Formally, there will be a dispute settlement procedure kicking in, ultimately leading to a suspension of the relevant part of the agreement, the way it's stopped. This has never happened.
This has never happened.
This has never happened. And it doesn't mean that we are comfortable with all these developments. I mean, we are including 600 to 700 acts a year into the agreement, and some raise political questions or difficulties. That's obvious. I wouldn't like to name examples in public and pinpointing certain of our member states, but that of course happens. And this element of trust kicks in there. Because there is a fundamental understanding and trust among us and the EU that we are dedicated to the fundamentals of this cooperation and the homogeneity principle and the dynamism that Finnur was underlying. Because we trust each other on these fundamentals, when we're faced with political problems, I mean, this remains set up a system that for a political system for cooperation among countries, among ours with the EU, also within the EU, there's politics involved. That then what happens is we start talking, and we try to find solutions. We trust each other's goodwill to actually get to a landing zone where we feel comfortable. And sometimes it takes time, because time helps so often in politics. The outcome being some adaptation to the act to be incorporated, or some common understanding. Oftentimes also some domestic deal, political deal, where some assurance are being given to those political circle that are concerned by such and such act. And then we come to a landing zone. So this element is fundamental, and this is why it ends up working, because we want to help each other out. We don't live in a system of where a partner is being arm twisted on anything essential into something a country doesn't want. We find solution based on this goodwill. Sometimes it takes time, so it becomes a de facto a political negotiation that has always yielded solution in the past, and it has always because we want to help each other out on the basis of this trust. So
excellent. Thank you both. Yes.
I just want to make two very short comments on that, because I think we see often rather the opposite, that if an act is very important for one of our three countries, they would say, listen, we need this one really quickly. Then the other states would say, okay, we'll try our best. So I think this is an important part of it. So just to have said that, yeah. And the other point I forgot. So.